This is Barry Zalma on insurance. Insurance policies have various types of conditions, one of which is called a warranty. And a warranty in an insurance policy is a special type of promise that must be kept by the insured when making a policy or when making a claim to a policy. Warranties in insurance contracts are of two different types, affirmative and promissory. The affirmative warranty is either express or implied. The promissory warranty is always an express warranty. Express warranties relate to the present or past existence of particular facts relating to the risk upon the truth of which the validity of the contract depends. A statement of fact becomes an express warranty when the insurer and the insured comply with, in the state of California, California Insurance Code Section 443, which provides, quote, every express warranty made at or before the execution of a policy shall be contained in the policy itself or in another instrument signed by the insured and referred to in the policy as making a part of it, close quote. Some examples of express warranties include the following statements. 1. My business is a partnership. 2. My building is reinforced brick. 3. I have never been canceled by any insurer. Or 4. I am 45 years old and have never smoked cigarettes. The California Insurance Code further explains the concept of the express warranty by saying, quote, a statement in a policy of a matter relating to the person or thing insured or to the risk as a fact is an express warranty thereof, close quote. That's California Insurance Code Section 441. The violation of an express warranty will void a policy in its entirety. In a British case, A.C. Ward and Sons versus Catlin, a 2009 decision, the commercial court, the insurers attempted to avoid coverage on the failure of an alarm system warranted by the insured to work. The court concluded that the warranty was not limited to the particular protections specified in the proposal or application form, nor was the alarm warranty confined to such alarm systems as might have been identified in the schedule. As a matter of commercial common sense, the warranties referred to whatever protections or alarms actually existed, whether identified in the policy documentation or not. As to knowledge, the court adopted the view that a breach of warranty could occur only in the event of a defect of which the insured was or should reasonably have been aware, and which it had then failed to remedy promptly. However, even though the alarm warranty was not effective, the insured also promised that theft coverage for cigarettes and tobacco in a warehouse was not operative outside of business hours unless the stock was kept within the special, secure store on the ground floor. Since they were not on the first floor, the insured was not allowed to recover. Federal admiralty law requires strict construction of express warranties in maritime insurance contracts. Admiralty law requires the strict construction of express warranties in marine insurance contracts, and breach of the express warranty by the insured releases the insurance company from liability. Lexington Insurance Company versus Cook Seafood, a 1988 decision of the 11th Circuit, affirmed a judgment in favor of the insurer based on breach of a navigation warranty. Affirmative warranties are different in this respect. An affirmative warranty asserts an existing fact or condition which appears on the face of the policy or is attached thereto and made a part thereof. It is limited in time to the moment of the application. The following statements are examples of an existing fact or condition that can be warranted in a policy of insurance. 1. The property is protected by a fire sprinkler system. 2. The roof is composition tile. 3. There is a silent central station burglar alarm system. 4. I have been treated for high blood pressure. 5. I have not been treated for high blood pressure. 6. There is a watchman on duty at all times the business is closed. 7. All business records are kept when not in use in a fireproof iron safe. When an insurance policy's full-time work eligibility requirement is an affirmative warranty, a breach of an affirmative warranty cannot be a ground for rescission of the policy unless the insurer relies on the affirmative warranty and the affirmative warranty is either material or made with the intent to deceive, or the fact falsely warranted contributes to the loss. When plaintiff stated that the Wisconsin law limits an insurance company's ability to void coverage and argued that undisputed facts do not satisfy these limits, an affirmative warranty was upheld. An affirmative warranty is one which asserts the existence of a fact at the time the policy is entered into, and appears on the face of said policy or is attached thereto and made a part thereof. In Reed versus Hardware Mutual, a 1969 decision of the South Carolina Supreme Court held that designating a residence as owner-occupied is an affirmative warranty rather than a continuing warranty, and does not preclude the named insured from recovering under the policy after the premises is sold to another party. Because the insurance contract contained a description of the dwelling insured as being owner-occupied, the provision was an affirmative warranty, not a continuing warranty that the dwelling was so occupied by him at the time the contract was made, and further, as long as the policy was in effect. A promissory warranty applies to the date of the application and the future, unlike the affirmative warranty. It is a statement of a promise to keep a certain fact or set of facts in existence throughout the period of the policy. Failure to comply during the effective dates of the policy is a breach of a material warranty that actually invalidates the policy. Promissory warranties require certain actions or non-action of the insured after the policy has been entered into, in order that its terms shall not thereafter be breached. Some examples of promissory warranties include the following statements. I will keep my premises protected by a silent central station reporting fire alarm system. I will have a watchman on premises whenever my business is closed. I will have a security guard on premises when I am open for business. I will keep my safe locked at all times when I am closed. I will keep records sufficient to allow my insurer to determine the exact amount of any loss without assistance or explanation from me. A promissory warranty is a warranty that facts will continue to be stated throughout the policy period, such that a failure of the warranty provides the insurer with a defense to a claim upon the policy, and is sometimes called a continuing warranty. Maritime law dictates that a breach of a promissory warranty in a maritime insurance contract excuses the insurer from coverage. The California Insurance Code does allow an excuse for failure to fulfill a future warranty, but only as follows, quote, when before the time arrives for the performance of a warranty relating to the future, a loss insured against happens, or performance becomes unlawful at the place of the contract or impossible, the omission to fulfill the warranty does not avoid the policy. That's California Insurance Code Section 446. Some warranties aren't stated at all. They are implied. So a ship repairer potentially faces 3 sources of liability for repairs he performs improperly on a vessel. He may be liable in contract for a breach of his express assumed obligations, or for breach of an implied warranty of workmanlike performance that attaches to the admiralty contracts, as well as for the maritime tort of negligence. An implied warranty is not specifically expressed in the policy language, but from the actions of the parties to the contract, a court, as a trier of fact, finds it to be the basis of the insurance contract. For example, there's an existing sprinkler system at the time of purchase of insurance and at the time the insurer inspected the property. At the time the insurer inspects the property, there's an on-site manager who tells the inspector he has worked there for 15 years. Or the insured, without being asked, provides the insurer a monthly report of values at risk. The breach of a single warranty at the time of the application keeps the policy from attaching to the risk. Nothing is or was insured because the insurer and the insured never agreed on the terms of the contract of insurance. The insurer was deceived, and the contract is therefore void or voidable at the request or insistence of the insurer. Although a breach of an implied warranty is rooted in contract theory, claims for breach of implied warranty and breach of contract are distinct and separate. Breach of an implied warranty and strict products liability causes of action are similar. Under both theories, a manufacturer is liable if the product is defective and no proof of negligence or fault is required. Moreover, if the legislature intended breach of contract to mean breach of implied warranty, it could have expressly said so, and when it did not, it was unable to void the coverage. In the maritime insurance context, the Second Circuit has defined a warranty as a promise by which the assured or insured undertakes that some particular thing shall or shall not be done, or that some condition shall be fulfilled, or whereby he affirms or negatives the existence of a particular state of facts. New York's insurance law defines a warranty as any provision of an insurance contract which has the effect of requiring, as a condition precedent of the taking effect of such contract, or as a condition precedent of the insurer's liability thereunder, the existence of a fact which tends to diminish, or the non-existence of a fact which tends to increase the risk of the occurrence of any loss, damage, or injury within the coverage of the contract. every warranty at the inception of the policy is presumptively material to the decision of the insurer to insure or not insure the insured. The existence of any false material warranty prevents the policy from attaching to the risk, even if the breach was innocent, unintentional, and without fraud. California Insurance Code Section 449 provides, quote, a breach of warranty without fraud merely exonerates an insurer from the time it occurs, or where the warranty is broken in its inception, prevents the policy from attaching to the risk, close quote. Therefore, if it is breached at the time of the inception of the policy never existed. It is the obligation of an insured to inform its insurer of every material fact necessary to the decision of the insurer to insure or not insure a risk, whether asked or not. A statement or promise set forth in a policy or by reference incorporated therein, the untruth or non-fulfillment of which in any respect, and without reference to whether the insurer was in fact prejudiced by such untruth or non-fulfillment, renders the policy voidable by the insurer, wholly irrespective of the materiality of such statement or promise. Since warranties are required to be literally true for the policy to attach to the risk, the question of materiality is not an issue. An untrue answer, even if it relates to an immaterial matter, could at that point in time, if warranted to be true, prevent recovery upon the policy. Therefore, if a misstatement appeared as to a matter warranted to be true, it is no defense that the insured acted innocently or in good faith in so doing, and there can be no recovery, particularly where the matter that is warranted is material to the risk. The California Insurance Code, for example, is quite clear on the subject of what remedy is available to a party to an insurance contract when a warranty is violated. The violation, it says, quote, of a material warranty or other material provision of the policy on the part of either party thereto entitles the other to rescind, close quote. This is California Insurance Code Section 447. Therefore, simply stated, a violation by the insured of any one material warranty is sufficient to void the insurance contract. Insurers are also subject to an implied warranty. The implied warranty of good faith and fair dealing first enunciated in 1766 in the British House of Lords in a case called Carter v. Beam, where Lord Mansfield, writing for the Lords, wrote that good faith forbids either party, by concealing what he privately knows, to draw the other into a bargain from his ignorance of the fact and his believing the contrary. The implied covenant explains that no party to a contract of insurance should do anything to deprive the other party of the benefits of the contract. This video was adapted from my book, Zelma on Insurance Claims, Part 102, 3rd edition, which is the second part of the 10-part treatise, Zelma on Insurance Claims, all of which are available as Kindle books and as paperbacks from Amazon.com, and some are even available as hard copies. If you found this video to be useful to you or your colleagues, please pass it on. It's free, and please also subscribe to my YouTube channel and my Rumble channel, or both. And please click on the like button or the Rumble button as you view this video. Please also subscribe to my blog, my Substack publication, my Locals channel, and thank you for your attention.